Hello, everybody, and welcome. Thank you for coming to the 2023 Klinsky Lecture. I'm delighted to introduce Sherrilyn Ifill as our 2023 Stephen and Maureen Klinsky Professor of Practice for Leadership and Progress. Let's give her a big round of applause. I want to start by taking a moment to recognize Stephen and Maureen Klinsky. I'm sorry that Maureen couldn't join us today, and I want to say a few words about both and the gift that made today possible. So Steve holds a JD and MBA from Harvard. He is the founder and CEO of the renowned private equity firm New Mountain Capital. He's also a deeply committed philanthropist and educational reformer. He founded Modern States Educational Alliance, a very important nonprofit that aims to make college more affordable. He's also founder of the Gary Klinsky Children's Centers and Victory Education Partners. He's a great friend of HLS and a trusted advisor to me on the Dean's Advisory Board. Maureen is a graduate of Cornell University. She spent 12 years on Wall Street before earning her MFA at Columbia. She's a best-selling novelist, and she's on the board of nonprofits dedicated to the environment, to financial literacy, to college affordability, and more. 10 years ago, Steve and Maureen had the inspiration to start the Stephen and Maureen Klinsky Professorship of Practice for Leadership and Progress. And here's what it does, and you'll see what a great idea it was in a moment when we introduce our speaker. It allows us to bring leaders from a range of professions to teach our students, to share advice and learning, and to broaden our perspectives. And the idea is to bring to our campus great minds and consequential people, and Sherrilyn Ifill fits that bill perfectly and is the 10th distinguished individual to hold the Klinsky Chair. So I want to thank Stephen and Maureen for their generosity and their commitment to the next generation. So let's please join me in a round of applause for them. And before I introduce Professor Ifill, I'd like to invite Steve up to say a few words, if you would.
Thanks. My wife, Maureen, and I are very proud to be associated with the law school and this professorship. As I've said in past years, I still remember very clearly, you used to get your acceptance or rejection in an envelope. And I still remember very clearly getting the thick envelope, and it changed my life, and it was incredibly formative. And I'm so pleased that all of you got the digital form of the envelope and are here, and hopefully we'll have great future careers. So it is just to bring great thinkers, great fresh perspectives to the school. Very proud to be associated with it, and I look forward to the remarks today. Thank you all very much.
Thank you, Steve. So I'm really, really delighted to introduce our Klinsky professor, who is a great civil rights lawyer and scholar, Sherrilyn Ifill. Let's give her a big round of applause. From 2013 to 2022, Professor Ifill served as the President and Director-Counsel of the NAACP Legal Defense and Education Fund, or LDF. In 2024, she will become the inaugural Vernon L. Jordan Chair in Civil Rights at Howard Law School, where she will also become the founding director of the 14th Amendment Center for Law and Democracy. Professor Ifill began her career as a fellow at the ACLU. She then went to the LDF as assistant counsel, where she litigated voting rights cases. In 1993, she joined the faculty of the University of Maryland School of Law in Baltimore, where she taught civil procedure and constitutional law to thousands of law students and pioneered a series of important and impactful clinics. She's also a prolific scholar who is now in the process of writing an important book about race and the current crisis in American democracy, entitled Is This America? And as President and Director of Counsel at LDF, Professor Ifill led the organization in groundbreaking litigation, advancing racial justice in areas such as voting rights, economic justice, education, and the criminal legal system. She raised the profile of LDF. she grew the organization in staff, resources, and impact. We are honored today to be joined by one of America's premier civil rights lawyers. Please join me in welcoming our 2023 Stephen and Maureen Klinsky Professor of Practice for Leadership and Progress, Sherrilyn Ifill.
Wow, thank you so much. I was telling Dean Nagin that I love the pre-applause, because you can't be sure of the post, but when you have lots of pre-applause, you can keep that in your memory. I'm absolutely thrilled to be here. This is the same room where I did the Biddle lecture, I think, yeah. And enjoyed that as well. And I want to just thank first of all Dean Manning for being so gracious and welcoming to me, both for the Biddle lecture and for this wonderful opportunity created by the Klinsky family, which I have enjoyed tremendously. I love the name. I'm very long-winded and I love like M dashes and ellipses. And so visiting professor of practice for leadership and practice, that's like my kind of thing, like 3 different things. And I've taken it very seriously. It's an opportunity, I think, to engage with students a little bit outside of the necessary rigidity of law school curriculum. Hi, Yi. And so I've taken quite seriously the opportunity to do that. I've completely enjoyed my semester here. This was my return to teaching. I had not taught formally in a decade. And I've had 20 extraordinary, bright, sensitive, and engaged students, some of whom are here, and who have made this semester so enjoyable for me. And so I thought, as the subject of my talk today, I would share a bit about what I've been up to with them and where I am going with this project that I am taking to Howard. Now, if you heard the Biddle lecture, you know that I believe and say often that we are in a democratic crisis. I see no reason to pretend that we are not, and in fact, I see a danger in pretending that we are not. In that lecture, I talked about the critical importance of law and lawyers in times of democratic crisis, and I stand by that. And I get pushback, about that idea, which I welcome. But I feel quite strongly that whether you like it or not, lawyers end up having an outsized influence on democracies. And so I take very seriously who we are in this moment in our country. We will not get a pass if we don't take up the mantle of what has been presented to us and what we must do. I also am unabashed in my belief in the importance of law itself to the health of democracies. As an organizing principle for fairness, justice, and equality, I regard law as an essential structure. And, I'm very much driven by the fact that I am an heiress to a whole cadre of extraordinary lawyers who managed and figured out how to use law to make this country better, to inch us towards greater health, and to move us towards the promise of democracy. Those lawyers, those extraordinary civil rights lawyers, the Charles Hamilton Houstons and Thurgood Marshalls and Constance Baker Motleys and Pauli Murrays and Spotswood Robinsons and so on and so forth, and Betsy Bartolet, made my life possible, and many of yours. Probably all of yours. You just may not realize it. I do think that part of the crisis we're in is a law crisis, a crisis in the rule of law, in the legitimacy of law and legal actors, of lawyers, and of judges. But along with my doomsday predictions about crisis, I'm also unfailingly optimistic about the possibilities of this democracy. And as I was sharing with Sasha earlier, I'm of the firm belief that it is precisely when we are in times of democratic crisis and when the status quo, the received wisdom, is unraveling and no longer is suited to the moment, that we have the opportunity to make transformative change. And therefore, this is precisely the moment when we must lean in. And in order to lean in, we have to have a vision of what we want this democracy to be. My own belief is that we've run out of runway on the old vision. It's not working, or we don't believe it, or we didn't create the foundations to make it strong enough, or time and circumstances and changes have overtaken us in the world to the point where the tools that we used to use and the vision that used to nominally hold us together no longer works. So I am optimistic that this is a moment that we can lean into. I will also say that I was going to say I have a soft spot in my heart for this country. Maybe that's a way to describe it, in that I truly believe that the project that this country is trying to undertake is one that has not been undertaken seriously and not been achieved, at least consistently, in any other country in the world. We are trying to create a multiracial democracy premised on ideas of equality and justice. And we are doing it with a history that suggests that we are ill-suited to do it, right? We're doing it with a history of chattel slavery, not in the colonies, but on our land. We're doing it despite the fact that in order to settle this land, we committed mass killing and genocide. We're doing it even though we held people in bondage, even in spite of Jim Crow. And to me, that is a huge task. So I cut us slack on the fact that we're trying something incredibly difficult. But I also take seriously that if we achieve it, if we get closer to it, and I think it's an iterative process. I don't think we get to the one day where America is the perfect democracy. But the closer we come to it, the closer we bring the possibility that other countries in the world can do the same, will believe they can do the same, will have tools, ideas, and a template for doing the same. The project I've just described, of course, was not the original project of our country. It was not the 1789 project, but it was the 1866 project, the post-Civil War American project, often called the Second Founding. And this is the project that, in my view, is the most relevant for the challenges and struggles we confront today. Maybe it's precisely because that second founding, its promise and its potential, were hijacked soon after Reconstruction began, hijacked by the Supreme Court in a series of hostile rulings at the end of the 19th century, hijacked by the inaction of Congress for the first half of the 20th century, hijacked by the unrelenting threat of white supremacist violence, which remained a feature of Black life from Reconstruction and into well beyond the first half of the 20th century. But that effort, that post-Civil War effort, which sought to bring Black people, free and formerly enslaved, into full citizenship, which introduced the concept of equality, which reordered the balance of power between the federal government and the states, which moved national citizenship to the foreground and recognized the need for protection against state action, is an extraordinary one. And so at this moment of unraveling, I see enormous possibilities. But I don't pretend that it's a small thing to imagine a way forward. And so my instinct is born not only of my optimism, but also of pragmatism, which is, as I said at the Biddle lecture, that we can't afford to throw out the baby with the bathwater. That is, we should be mining our system for some of the gems, some of the tools that actually work, some of the nuggets that were inspired. And for me, the principal touchstone is the 14th Amendment. Not only because it's been the principal tool of litigation for me as a civil rights lawyer, but because in its promise, its power, and pragmatism, it is, in my view, the most dynamic and most powerful, potentially most powerful provision of our Constitution. Many of us know the 14th Amendment for the guarantees contained in Section 1, birthright citizenship, protections against state interference with privileges and immunities, protection against state interference with due process, guarantee of equal protection. That would be enough. I mean, that's huge. But I'm more interested in the way in which the 14th Amendment is really the only provision in the Constitution, to my mind, that confronts with a measure of honesty the fact that those very guarantees and the project of this democracy are threatened by two powerful forces from within, the stubbornness of white supremacy, and the threat constituted by the spirit of insurrection. And we'll talk more about that later. So here's section 1, the part that we all learn in law school, mostly the only part that we all learn in law school, which includes, of course, in that first sentence, birthright citizenship, terminology we mostly hear about in the political realm, which includes the Privileges and Immunities Clause and due process and equal protection. And we kind of take for granted that that is the 14th Amendment. We know that this amendment was designed to address conditions following the Civil War, but I think we don't think about what those conditions were. We don't think about the fact that the country was decimated, that 600,000 people were dead, that there now was a population of millions of Black people for whom much of this struggle had been fought and who now had the promise of becoming true citizens of the country, that we had a recalcitrant South still after the Civil War, that we had mass violence, some of the worst violence we've seen, white supremacist violence, happening in the South in this period. And then to make matters worse, the person who had led the country through the war and who many believed was uniquely positioned to hold together the Union was assassinated. I mean, just absorb what that must have been like to try to now create a new nation under those conditions. And let's give credit where credit is due. These provisions are pretty extraordinary. We know that the framers, however, didn't spend a whole lot of time on Section 1. They were kind of interested in the other sections. But that doesn't mean we shouldn't. And certainly, the lives that many of us expect to live in this country and our sense of kind of the legal order in this country is as much derived from Section 1 of the 14th Amendment as any other provision of the Constitution. The way in which you live your life, what you think you can do and can't do, what you are entitled to and not entitled to. And so it's lovely to talk about our original Constitution, as we do, often, the Bill of Rights and so forth. But I think, and maybe this is part of the project I'll talk about, there does need to be some curricular change in terms of the attention that we give to the Civil War amendments. Section 2 of the 14th Amendment is one that I didn't learn in law school. I don't know how many of you have learned it. It's kind of important. And it goes to my point about the architecture of this extraordinary provision. Section 2 essentially says that, number 1, that representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons of each state. And of course, that was designed to overturn what provision of the Constitution? The 3/5 compromise, right? So just like that, we're talking about transforming a provision of inhumanity to humanity. These are not small things, whole persons. Whole persons. And then it goes on to set forth a regime of punishment for the failure to allow, in this case, really targeted at Black men, the failure to allow Black men to vote. Essentially what it says is it's speaking to Southern states, and it's saying, to the extent that Southern states continue to keep Black men from voting, remember we don't have a 15th Amendment yet, their representation will be reduced by the number of people they disenfranchise. That's pretty powerful. It's powerful for 2 reasons. Number 1, it recognizes, it's an implicit recognition by the framers that the South is unlikely to comply with the idea that Black people are full citizens entitled to political rights. It's a recognition that there is likely to be ongoing resistance and intransigence. And the second reason it's so powerful is that it is saying to us, the Republic, if you want the guarantees of that first section, you're going to have to do some things. You're going to have to come hard against those who try to keep this democratic process or promise at bay. One might ask why we've never imposed this. I mean, we ended up with the Voting Rights Act after the Civil Rights Movement, which is great. And since it appears that it's on its way out, maybe we should return to what the framers, the men who had stared insurrection in the face and stared white supremacist violence in the face, decided was the appropriate way to deal with what we call voter suppression or disenfranchisement. This section is also important because it's the first time the word male appears in the Constitution. And we'll come back to that later, which caused no small measure of consternation. The third section is also fun and much in the news these days. The third section recognizes the stubbornness of the spirit of insurrection and the danger of it to this new republic. And so the third section says that if you participated in insurrection or rebellion, if you are someone who previously took an oath, you were an office holder, you were a judge, you were the president, I would say, and you participated in insurrection or rebellion, you cannot hold office at either the state or federal level. I've got some representatives in my own state of Maryland that I got my eye on, all right? Who were at some meetings and did some things in 2020. But that's what they said. I'm not making it up. That's what they said. And they didn't put it in a statute. They could have. They put it in the Constitution. And as we'll get to in a moment, it's because they understood that this spirit of insurrection was stubborn. It wasn't something that was likely to simply pass. So that's section 3. I'm going to skip section 4 because we just don't have the time. So when we talk about framers, most often we think about, if I asked you who were the framers of the Constitution, you would say Madison, Hamilton, Jefferson. They've got whole plays about them and tomes and homes that we tore and so on and so forth. And we don't talk about any of these guys. We don't talk about Charles Sumner. We don't talk about Thaddeus Stevens. We don't talk about John Bingham, who really authored Section 1. We don't talk about these guys. When they're the framers of the Civil War amendments that essentially are the framework for the life that we live. We're obsessed with the guys in the tricorn hats. I have nothing against them. I'm a sentimentalist. I get choked up when I go into Independence Hall in the chair with the sunrise on the back. I'm into that stuff. But it is at the expense of recognizing the second founding and the significance of these individuals. And these individuals are important because, as I said earlier, these are people who looked in the face of insurrection. They looked in the face of white supremacist violence. Charles Sumner was beaten on the floor of the Senate in 1856 by a pro-slavery South Carolina Senator, Preston Brooks, who used a walking stick to cane him almost to within an inch of his life. Waited until the chamber was almost empty and the ladies had been cleared from the hallway, and with 2 seconds holding at bay other senators who would have intervened, beat Charles Sumner over the head with a gold-tip cane. Beat him so badly that the cane broke, and then Brooks continued to use what was left of the cane to continue the attack. Because Sumner had given an anti-slavery speech, and in it had named someone who was a distant relative of Brooks. So these are people who actually knew, and having known, were very clear that we were going to need some heft to be able to pull this off. These men had also read the report of a Joint Commission on Reconstruction, a congressional commission, which had detailed the deep and profound formational ideologies of white supremacy and states' rights that existed in the South. And so they knew that in order to hold the new republic, we would need not only these soaring guarantees, but tools of enforcement. And of course, we know that Section 5 of the 14th Amendment gave Congress the power to enforce the guarantees contained within, which was their way of saying that we can't count on the states. It's going to have to be the federal government that will ensure these rights. But the premise of the class that I'm teaching now, of the center that I'm creating, and of my own thinking, is that Framers and founders are not only those who were elected to office and sat in the legislative chambers like these men drafting constitutional and statutory provisions for the new nation. And here I'm following the powerful research of historian Kate Masur, who visited our class this semester, whose latest book, Until Justice Be Done, is masterful, and I strongly and highly recommend it to you. And it recounts the many influences that helped shape and infuse the words, the concepts, the ideals that were codified in the Civil War amendments and the Reconstruction statutes. She and also historian Martha Jones, who now teaches at Johns Hopkins, who also visited our class, recount the ways in which free Black people were influencing concepts of citizenship in the decades before the Civil War. And so if we think about the provision of birthright citizenship, which is the first line of the amendment, and I wish to point out again that birthright citizenship was not necessarily the norm during this period. This was kind of an innovation, that you were the citizen of the place that you were born. And it transformed this country. Probably most of the people in this room have been touched by this in some way, that you could be a full citizen of the country with all the rights therein simply by being born here. And Martha Jones, in a conversation with me several weeks ago, described it as whatever was the disparagement visited on the parent, that disparagement would not follow the parent to the child. Which is very powerful, right? That you could have a child who was born here, and whoever you were, theoretically, this is all theoretically, of course, the disparagement of being not fully a citizen would not follow. And that in and of itself is powerful. And at some point, someone needs to study that as a motivating idea of how we think about immigration in this country, especially since people keep saying that they're going to end birthright citizenship as though it's not a constitutional provision. Okay, so so this is just one section, and I'm just using this example, this one line. And so we spent time talking about the role of Black sailors in the 19th century in shaping ideas about citizenship. To be a sailor as a Black person during this period was very profitable. It was an entry-level job for Black men. There was prestige in your community if you were a Black man and you were a sailor in the years before the Civil War. That was kind of a big deal. These are people who were visiting ports, not only in this country, but throughout the hemisphere. And as they went to those different ports in South America and Central America, there were differing views of citizenship. And they were having different experiences that suggested who they might be. But here, these sailors who were in these coveted jobs were running square into white supremacist laws. So we looked at the case of Gilbert Horton, a young man who was a citizen of New York. He was this is not him. This is a sailor, but it exemplifies him. It's important because you have a uniform, and that was a big deal. So he was a citizen of New York. His ship came to Washington, D.C., and Washington, D.C. had a law that if you were on the street as a Black man and you were questioned and you could not adequately explain who you worked for, you would be imprisoned. You'd be taken to jail, and a notice would be placed in the newspaper for 30 days. The notice was not really for the person who was jailed. It was actually for the presumptive owner of the person who was jailed. And so this notice would go out, and for 30 days, they would wait to see if someone came to claim this person. And if no one came to claim you, then you were sold into slavery. Gilbert Horton was a free man, a sailor from New York. He gets picked up on the streets of Washington, D.C. And this is the advertisement. This is actually not, this is the advertisement of people who now tried to help him. Because he was from upstate New York, Westchester County. And when the notice went out, some people there recognized him. They knew him. They said, yeah, he's free. And they started to hold meetings, try to figure out how they could get him out of the jail. And these powerful people, some of them abolitionists, began to really work on his case and use his case as an exemplar. It was a big deal because he was in the DC jail, so he was in federal custody. So this was an embarrassment to Congress, an embarrassment to Lincoln, and so forth. And so they worked this whole system. His case became a cause célèbre. They were ultimately successful in getting him out. Your right side, this is a listing of prisoners, and that designation FMC is free men of color, including visiting sailors who, as I told you, could be kept in jail. In Louisiana, the law was that when a ship came into port, they took all of the black seamen off the ship and put them in jail. And there they would stay until the ship was ready to leave port. And if the captain of the ship didn't come back and claim the men from jail, then they also were sold. So the Port of New Orleans had an even more onerous, this is New Orleans here, had an even more onerous set of laws that governed the lives of black sailors. And you can see why. This quotes from the New Orleans Commercial Bulletin, that black sailors, they feared, are the worst evil that threatens the South, describing black sailors as most dangerous to our institutions, carrying on the work of insurrection and massacre. And this is because black sailors were coming with these ideas from these other ports about who they were and who they could be. And there was this continuous fear of free black people's sense of citizenship as kind of infecting the South. And so we explored the idea of these sailors influencing this concept of citizenship and themselves being therefore part of the framing and founding project, because the ideas about citizenship and what would be significant in order for black people to be able to exercise citizenship was very much influenced by these cases. How powerful the right to travel was for black people who could be questioned on the street by any white person. But there were other framers as well. This man is Carl Schurz. He was German-born and then lived here in the United States. He was sent by President Andrew Johnson down south to observe and report back on the conditions in the South in 1866. Andrew Johnson was, in my view, one of the worst presidents we've ever had, but he certainly was, he was a unionist. He believed in the Union, but he had no problem with slavery. He was from Tennessee, and but he understood his job after Lincoln was assassinated. But what he wanted to do was bring all the Southern states back into the Union without them going through any loyalty tests or anything. He just thought, let's, game over, we won, and now let's just move forth. And so he sent this emissary down south to do an investigation to prove that that was true. But when Carl Schurz started to do his investigation, he found that not only was it not true, but that in fact, conditions were quite dangerous. And that the stubbornness of the spirit of insurrection was so powerful that he said that treason doesn't even seem like an issue for most of the people that he encountered. He said they have no appreciation for the criminality of the thing. He also found that the stubbornness of white supremacist ideology was unmoved, that white people were firm in the belief in the South that black people could not work unless they were physically punished. And he also said that there was this idea of ownership. And he said it may be true that no individual white person can now own an individual black person, but it is also true that to a man, almost everyone I encountered seems to be of the belief that all the white people own all of the black people. And so he writes this incredibly powerful report and gives it to Andrew Johnson and to Congress. And Andrew Johnson tries to be very jocular about it as though it doesn't say what it says. But it says what it says, and it powerfully influences those senators and congresspeople who are working on this project. And when you read his report, you can understand where Section 2 and Section 3 come from. And I point out that, I keep using the word stubbornness because this was the fear, that this was not a passing thing, but that it was strong and deeply rooted. It's no surprise to you that Frederick Douglass was a framer, maybe the most powerful voice, certainly the most powerful black voice prior to the Civil War and then through Reconstruction. And he had his own very clear understanding of what was happening in the South because, of course, he had been enslaved in Maryland and had escaped. and continued to speak and write around the country about the condition of slavery. And as I pointed out in an op-ed in the Washington Post this weekend, he was very clear that he believed that the spirit of insurrection, he said, would be passed from sire to son. He said, it will not end in a year, it will not end in an age. So for those who say, yes, but Section 2 and Section 3 was just about 1868, right? That was not what they believed. They believed this was essential to protect the Republic. The other thing that makes Frederick Douglass a founder and a framer is that many of you may know that Frederick Douglass was the most photographed man of the 19th century. He loved being photographed. He sat for many photographs, and he was so damn good looking. I'm not mad about it. But it was very strategic. He believed that, and he's written a whole essay. He wrote a whole essay about photography being the way in which we would realize ourselves going forward. Remember, photography is this new medium, this new artistic medium, that we will now be able to see ourselves. And he believes that by being photographed, and being photographed in the way he's photographed, I've seen a million photographs of Frederick Douglass. He's always very, stately and put together. Doesn't matter whether he's old, whether he's young. But what he's trying to do is to convey the dignity of a Black man. He believes that having seen these photographs, no one will believe that Black men are not men, right? So he's very powerfully influencing this idea of Black manhood and Black citizenship at a time when many in the country are not trained to believe that, both in the South and in the North, in the dignity of Black people. So he's conveying a message through these photographs. And this is also part of the process of thinking about how do we engage and how do we treat men in this country called America. And that influences the citizenship process. We know that founders and framers are also people who are pushing back against language and concepts. And so Susan B. Anthony and Elizabeth Cady Stanton are furious about that line in Section 2 that says male. It's bad enough that women don't have the vote, but now we've actually introduced the word, they say, that excludes women from being considered part of the body politic. And there's a huge struggle between abolitionists who had been joined with women around suffrage and abolition. And it causes this break. Now, not my guy, Frederick, he was a feminist and he believed in women's suffrage. He spoke at the Seneca Convention. But at the end of the day, there was this pragmatic concern about whether or not how far you could push on the 14th Amendment, and the belief that you could not push to ensure that women had the right to vote. But this was an incredibly contentious and powerful conversation, which ends up with the word male being in that Section 2 to push back against the men who were for the 14th Amendment in terms of Black suffrage, but who did not want their wives to vote and did not want this to be the back door through which women's suffrage was realized. So even in a negative sense, right, the women's movement are framers of the language of the 14th Amendment. So, January 6th necessarily brought many of our minds back to the period following the Civil War. Obviously, the violence we saw that day, certainly for me, was reminiscent of the violence that took place in Mississippi, in Louisiana, and other southern jurisdictions during Reconstruction. That's what it looks like if you've read the descriptions of attacks that happened on courthouses, usually over anger about the outcome of local elections, like the Colfax Massacre. They look like this. I say that while also saying that I don't think that anyone, not any of the framers and not Southern insurrectionists, could have imagined that the Confederate flag would be walked through the United States Congress. So we have that unique quality going for us. But it was incredibly reminiscent, and that means, to me, that we should be returning to that history to try to understand its relationship to today. The intimidation of election workers was also a feature of that period. This photograph is of Ruby Freeman and Shay Moss, mother and daughter, who you know were disparaged publicly by Rudy Giuliani and President Trump, who were accused of engaging in fraud and other activities during the election. There maybe is no more powerful testimony than Ruby Freeman, the mom, saying after she had to leave her home and had been overcome with death threats, there's nowhere, she said, I feel safe. And she asked the question, can you imagine what it's like to be targeted by the President of the United States? So all of this may feel disheartening, but my nature is always to find the seeds, the kernels that lead us to a formula for the creation of something better and stronger. And we have some history with having done this. I mean, the civil rights movement leaders and foot soldiers were founders and framers. Those who were martyred, the Jimmy Lee Jacksons and James Reeves, but also any other number of marchers in Birmingham, the children in the Children's Crusade, or those who marched in Anniston, Georgia, they were founders and framers. They weren't in the room in Congress writing the Civil Rights Act of 1964. They didn't write the provisions of the Voting Rights Act. Fannie Lou Hamer was no legislator. She never wrote a passage of the Voting Rights Act, but she was a founder and a framer, as surely as if she served on the House and Senate committees that wrote Section 5 of the Voting Rights Act. Lawyers who represented unsung civil rights challengers and protesters shaped our contemporary conception of the First Amendment right to protest as much as they shaped the drafting and provisions contained in civil rights statutes. And so what I've told my students and what I believe about myself and about all of us during this period is that we must have the courage to see ourselves as founders and framers of a new America that we are trying to create. Not that we are trying to create because we have been through an actual physical war or that we have to create from scratch, but that we have to create that we believe honors the best of us, honors our vision of an America premised on democracy. The raw materials we have are actually plentiful. The sheer determination of people in this country to believe in the apparatus of democracy is a powerful force. I'm a voting rights lawyer, so I see it all the time. These images from Reconstruction, from the Civil Rights Movement, and from the Wisconsin primary in 2020 are powerful evidence of that resilience, that determination. And remember in 2020, this image, you'll note the masks. This is, I want to say, the last day of March 2020. We are at the height of the pandemic when we don't even know a lot about it. But we know that it's deadly. We are nowhere near a vaccine. It's a primary election. At the time this photograph was taken, and it moved me so much, the bottom photograph. Although Black people constitute 28% of the population of Milwaukee, they were at that time constituting 75% of COVID deaths. And yet people still came out, masked, determined to participate. Maybe we take this for granted. Maybe when we look at a picture like this, we focus more on the fact that there shouldn't be long lines to vote, which is absolutely true. But there's something else here too. That same Reconstruction determination, that same determination from the Civil Rights Movement lives in us. And that determination represents a belief that the levers of democracy can yield change. And the willingness to risk it all, literally with your life in 2020, is incredibly powerful indeed. I spent years working for legislation to transform policing in this country, and we were not successful in 2021 in getting that legislation across the finish line. in Congress. We worked for a year on the George Floyd Justice and Policing Act. And I confess I now think quite differently about some of the provisions that are needed to reimagine what systems of public safety should look like in a democracy. And I've read many cases, litigated, delved deeply into the history of policing, engaged with community leaders and organizers. But what most powerfully shapes my image, frames my thinking about what is necessary, is this image, which you may recall from 2016. This image is of a 35-year-old nurse named Aisha Evans, who confronted police officers in Baton Rouge, Louisiana, during a protest after the killing of Alton Sterling, an unarmed Black man. 24 hours later, Philando Castile was killed in Minneapolis. The photograph is by a Reuters freelance photographer, Jonathan Bachman. And this photograph is what guides my thinking about what a public safety system should be in a democracy in the following way. This woman is utterly vulnerable. She's wearing a sheer summer dress. She has no weapons. She doesn't have a purse. She has a phone. You can't see the full measure of the dress, but you can see that the top is backless, the legs are out. And what you also, it's difficult to see in this photograph, are the legs of the officer, who is literally brought up short. Like his legs are out. He's like, was charging forward and brought up short by this woman. Not because she had a gun, not because she was hulking, but just the sheer courage and determination of this woman. And what she said was the reason she did it was, she said, I just needed to see the officers. I just needed to see them. She said they had on these masks and these, things over their face, and I needed to see them. And she said, I'm human. I'm a woman. I'm a mom. I'm a nurse. I could be taking care of you. Our children could be friends. We don't have to beg to matter. We do matter. She was arrested along with other protesters that day. But this image has stayed in my mind. And if I have any role in helping create national legislation around policing, she will have been a powerful framing influence for me in what I think has to be the relationship between law enforcement and the population. What should bring them up short? What measure of delicacy should be able to be on display in the face of law enforcement? The disproportionality between how they are dressed and how she is dressed. Is how they are dressed really necessary? How she's dressed is actually necessary because it's summertime in Baton Rouge. But how they are dressed, is it really necessary? And so much of what I've been thinking about, the provisions that we have to tweak and tinker with, are driven by this photograph. And that's not unusual. That's not unusual. We talked before during the Biddle lecture about the images from the Edmund Pettus Bridge, the night of the first showing of Judgment at Nuremberg on CBS, and the breaking news interruption to show those images. That was March of 1965, and by August, we had a Voting Rights Act. That's how powerfully the country was moved during this period in which they were watching a film about Nazi Germany, and now seeing these images on the bridge had to figure out, who are we as a democracy? And so I truly believe that this project is one that is not just about law and policy, although that is my specialty. I believe that it is also about imagination, if we're going to imagine a new democracy. And the people who know more about imagination than lawyers and lawmakers are artists. And so I believe that there must be a part of this project that engages artistic expression. What influences our sense of who we are as a democracy? At this time, I'm now working with a number of artists, but I think just to exemplify what I mean, if you think about Jacob Lawrence's Great Migration, an extraordinary set of work, 31 panels about this process, the migration series, what it means to strive within your own country for freedom, right? We spend a lot of time talking about immigration. We don't talk about migration within our own country, a lot of which is happening now, by the way. But what this represents, what New York and Chicago and St. Louis represented to people from Alabama and Mississippi and Florida. And if you've read The Warmth of Other Suns, for example, you know what I'm talking about. This is a work by the artist Glenn Ligon, and I'm going to be doing a talk with him tomorrow night at MoMA in New York. And what moved me about this particular piece, which is not even part of what we're going to talk about, is that I always talk about the moment when you began to see the strings of America. I mean, the things that hold it up. And that's a powerful moment. You know, if you can get past that moment and still love your country, you're really ready to do some good stuff, right? Not just the illusion, but the strings. You can see that this is all suspended by stuff. It's not because it's just natural and endemic to us. So I love this piece by Glenn Ligon. And then this is a piece by Mark Bradford, extraordinary artist who really works with layers. He layers like so many layers on top of layers on top of layers, and then he begins to tear the pieces, and what is revealed beneath is powerfully important. In some pieces, what's revealed beneath is a map when he's kind of exploring ideas of segregation. It's a map of old Los Angeles or old St. Louis. And I think that's a lot of our project. There are layers and layers and layers, and it's not that we rip off the whole thing and live in the past, but we tear off enough to see what lies beneath, to know where we came from, to know what lessons are there, to think through how many layers we have had to go through to get to the one that we are in, to understand we didn't just appear here, but that this has been a hard-fought battle. And so one of the things we're going to be talking about later with my class is what shapes your sense of our national identity or your aspirations. For me, they were songs. Apparently, they don't teach you all songs like this in school anymore, but when I was a kid, maybe some of you, we learned these little songs. Freedom isn't free. They were like these little patriotic, we were being indoctrinated, but it was great. And they were very influential and they were very powerful for me. They give us You're Tired, You're Poor. We sang these songs in the Glee Club. They really got to me, And so there were songs and there were films, there were movies that made me think, this is America, right? And I think that artists are going to be essential to helping us envision that. And so I ask, you to think about it. Was it a play that you saw that made you think, this is about the American family and the struggle and for whatever it was that entered your consciousness? Or was it the exuberance of American musicals? We were a big musical family in my house that made us just think that, life was just going to be singing and dancing, right? Or was it the struggle, that you see in West Side Story? The idea is to forge a robust interdisciplinary conversation between lawyers, policymakers, historians, educators, political scientists, and artists, to link us all in a project of imagination and ambition in which, guided by the radical vision that I see in the 14th Amendment, we identify the words, the language, the laws, the actions, the vision for a new America. I'm reminded of that powerful book and now, I think, HBO series, Five Came Back, about directors who served in World War II and came back and made some of the films that forged our sense of who we were in that war and after, the best years of our lives. It's a Wonderful Life, born of the struggle and pain, of William Wyler, who had been there when Dachau was liberated and was so horrified by what he saw, was wondering himself about the meaning of life, and played so powerfully by Jimmy Stewart for the same reason, because he had served as a bomber in World War II and was enjoying his own existential crisis. And these films powerfully shaped our sense of who we were, that we were the good guys, that we did extraordinary things, that small town America has these values, that our life is made up of what we give others. All of these things that we still watch to this day. They were not entirely unintentional. And so I think we have to acknowledge the role that artistic expression plays in helping us see ourselves and see who we want to be. And so next semester, I will be going to Howard to begin this center. I have been teaching this class at Harvard this semester, but also am engaged in this fellowship at MoMA at the Museum of Modern Art over the next, I've been in it for, a few months, but it'll be a year-long fellowship, to solidify this conversation so that we can begin to talk about what are the films, the plays, the art, the dance, that might embody a refreshed way of us thinking about who we are and can be as a nation. So that while we, the lawyers, are working on litigation and bringing the cases and drafting new statutes and thinking about constitutional amendments and thinking about incubating laboratories in courts and in other dispute resolution fora, we're tied together with those people for whom imagination is their bread and butter and what they do. And that we will not inhibit ourselves from believing that we too are entitled to imagine what our democracy can be. So thank you all very much.